Good morning, everyone. It's great to see so many of you have joined us this morning for the latest People webinar update. There's two speakers this morning, me, Rachel Phillips. I'm an associate in the London employment team, and I'm joined by my colleague, Michelle, who's a principal associate in the Birmingham employment team. This webinar is the first instalment of our three-part training series on managing disputes in employment tribunals. And we'll be with you for 30 minutes this morning covering this topic. We have two further webinars in January and March 2026, which will take you through managing employment tribunal proceedings and also exploring settlement. Today we're looking at pre-claim issues. That could be dealing with a difficult employee situation, which you think could escalate to a claim, or it may have gone beyond this and the employee has actually started a formal process by engaging with ACAS. We'll be discussing current trends in workplace disputes, the impact of the upcoming Employment Rights Bill, ACAS and early conciliation, protected conversations, and managing data subject access requests. And we'll kick off with Michelle giving us an insight into current trends we're seeing in workplace disputes.
Thanks, Rachel, and good morning, everybody. I have to say, I suspect a lot on the call work in HR or otherwise with employment matters, and the same for myself and Rachel. Employment law never likes to stay still, which is probably part of the thrill of our day. I have no doubt everybody would agree with. We tend to find that what was a hot topic last year, 6 months ago, even a few weeks ago, isn't necessarily the same a few months or a year or so later. But I think it's fair to say the headline tends to not come as a surprise that disputes in the workplace have been increasing, and steadily so, I'd say, over the last few years or so. Quite helpfully to us for the session today, ACAS commissioned a poll via YouGov back in August, where they took feedback from, I think, just over 1,000 employers based in Great Britain. Now, the headlines there, no surprise, I imagine, 44% of respondents said that conflict in their organisations had seen an increase over the last 3 years, and that's compared to only 13% who reported that they'd actually seen a decrease. And it matches the feedback that we get from ACAS themselves, that for the financial year 24-25, they'd seen a 13% increase in the number of individual complaints that they had dealt with themselves. And the survey showed that the top areas of conflict at that time was all around pay, working patterns, and capability and performance. Now, from our own experience of what we're discussing with our own clients at the moment, that pretty much matches what we're seeing as well. So we're seeing quite an increase in performance management, perhaps around looking at trying to get ahead of the curve for changes that might come in with the Employment Rights Bill, particularly with the day one unfair dismissal rights, to get used to performance managing from an early part in the employment relationship, or just to maximising your input and output and your performance as a business, that employers seem a little bit more hot on managing performance and capability at the moment. And this might also reflect as well another point that we're seeing, that at senior executive level, we're seeing quite a few more disputes, particularly around the point at which somebody's leaving. So on exit, of course, many senior people will have restricted covenants, sometimes on competing and other times not. But what we're seeing is a lot of individuals, but also if you're looking at a settled exit, a lot of their advisors are pushing quite strongly in negotiating on trying to lift or lower the post-termination restrictions. It's also perhaps not a massive surprise, I suppose, because we'll all be aware that the last year we had the preventative duty coming in terms of sexual harassment. There's been an increase in the number of complaints of sexual harassment. I don't necessarily think it means that sexual harassment itself has been on the increase. What this might reflect is the good work that employers have been doing since then to do refresher trainings and to really hit home with their employees in terms of how to recognise sexual harassment in the workplace, but also the options they have to report it so that employers can deal with that. Similarly, not on the slide, but what we are seeing quite a lot of as well at the moment is grievances and claims from employees who have neurodiversity conditions as well. So we're seeing a lot around reasonable adjustments and also issues with management of behaviours and performance resulting from that condition, and a bit of an increase in claims as well. On the flip side, it's always good to end with a good point, I guess. So for anyone on the call who deals with trade union issues and collective disputes, they've actually seen quite a drop between financial year 23-24 to financial year 24-25 from 618 to 522. the Office of National Statistics actually show a dramatic drop in the days lost to industrial action for employees taking part in strike action. So there was 1.85 million days lost to strike action in financial year 23-24. That went down to 597,000 in 24-25, which is of course still an eye-watering number, but I suspect from organisations' perspective, it's not quite as worrying as the previous financial year. And your experiences might well be different, or they might well mirror what we're seeing, but it feels like those are quite the hot topics at the moment. But Rachel, we know that the landscape's going to be changing over the next few years. So is there anything we're expecting to see in the Employment Rights Bill that might make an impact?
Yeah, of course. So with the Employment Rights Bill on the near horizon, this is inevitably going to have a pretty significant impact on workplace disputes. As I'm sure many of you are aware, the Employment Rights Bill is going to give more rights to workers as part of the government's wider plan to make work pay. Our colleagues did cover the detail of the Employment Rights Bill at the last webinar in October, and the recording is available, so it's definitely worth watching that if you were unable to join that session. The number of employment tribunal claims is very likely to go up as a result of the Employment Rights Bill. The government's own impact assessment estimates that they could go up by 15%, but we think the figure will likely be higher. The backlog of employment tribunal claims has increased by more than a quarter over the past year alone. And the Employment Rights Bill being introduced is inevitably going to lead to a further backlog. And unfortunately, there are no accompanying provisions to increase tribunal capacity to deal with claims. So there are obviously a wide range of changes being introduced by the bill, but we've highlighted the key ones we want to talk about today. So one of the most obvious ones, the removal of the 2-year qualifying period to claim unfair dismissal, is going to mean employees can claim unfair dismissal from day one, likely leading to a quite significant surge in claims in this regard, and also an increase in disputes over probationary periods and performance management during the first few months of employment. Also, the new rights to guaranteed work, to guaranteed hours and fair notice for shift cancellations for 0 and low hours workers is going to see an increase in claims where employers fail to offer these guaranteed hours or where they do cancel shifts without the proper notice. Also, changes to flexible working requests, which will mean refusal of an employee's request must now be reasonable. That could lead to more challenges from employees and disputes over whether an employer's refusal is objectively reasonable. So currently, an employer can refuse a statutory flexible working request on one of the 8 specific business reasons. That could be things like cost or inability to reorganize work. And the tribunals currently just check whether that process was followed. But now there's an extra element where they'll also have to check whether the refusal was objectively reasonable. Also, the increase to the maximum protective award for failure to consult on a collective redundancy process is going to incentivize more claims from employees following inadequate consultation, because that award is doubling from 90 to 180 days pay. So that's obviously quite a big incentive for an employee to bring a claim. And finally, the increased rights being given to trade unions could lead them to supporting more disputes where they might not have done so previously, perhaps, for example, focused on issues such as national minimum wage. There's also proposals to extend the primary tribunal time limit from 3 months to 6 months, and that's obviously going to increase claims and not help with the backlog. The provisions in the Employment Rights Bill will come into force over the next few years, so it's not going to be an immediate impact. For example, day one protection from unfair dismissal and the 0 hours protections I mentioned aren't being introduced until 2027. So whilst these new protections are going to take time to bed in, the disputes aren't going to wait. So we'll still want to resolve issues hopefully long before a claim reaches tribunal stage. And that's where early intervention becomes really critical. And one of the key tools for early intervention is ACAS. And Michelle's going to take us through how ACAS and the early conciliation process work and what some recent changes mean in practice.
Thanks, Rachel. And in practice, I suspect when you're dealing with a dispute with an employee or a former employee, you're probably going to have a very good idea of the ones that are going to fizzle out and not really cause you a headache, and then of the ones that are likely to become a claim. And you'll always, unfortunately, have those ones that fall in between where you might get that surprise in a few months' time and find that you've got early conciliation or else you've got a claim. Now, the category where you're pretty confident you're going to see a dispute doesn't necessarily, a claim, doesn't necessarily mean that you're going to have to go through the whole tribunal process, because you do still have options to try to resolve before you're knocking on the tribunal door. Now, we'll touch on early conciliation in a bit more detail because I think that tends to be the main one, but it's always worthwhile remembering that ACAS does also offer voluntary services, so conciliation, mediation or arbitration. The latter, you'll tend to see if there's major trade union disputes that have made it to the news, that there'll always be that filming shot outside an ACAS office, and that tends to be where the voluntary processes are more commonly used, but they are there for you as well. And there's also, of course, there's no requirement that you have to go out to a third party organisation. You might want to deal with something in-house. And so you've got that option there of a settlement agreement. And Rachel's going to talk to us more a little bit later about the option of protected conversations. And I'd say perhaps not used in all sectors very often, perhaps used in more sectors than others. There is also the option of private mediation via a neutral third party, whether that be a trained mediator individual or an organisation who offers those services. But for our purposes today, we'll focus more on early conciliation through ACAS. Now, it might feel, if part of your day-to-day job is that you're dealing with disputes and you're dealing with early conciliations, it might have come to feel like ACAS, early conciliation, has been around forever, but it was actually only back in 2014 that it was introduced. And it was very much introduced to a fanfare around, we want to try and lighten the load for employment tribunals and also for the parties involved to see whether or not things can be resolved amicably with the support of ACAS as that third party. Whether or not it's been successful will be from your own experiences. But I always think we've got a sort of screenshot here of what early conciliation process should look like. But I think there's some important points to always think about when you're thinking about early conciliation as an option or as something that you've been contacted about. So it applies to some claims, but not all. What we're seeing a little bit more of at the moment is individuals bringing interim relief applications, and that's one of the examples of a claim that doesn't require them to go through early conciliation first. So the first you'll hear about that will be when the tribunal claim lands on your doorstep. Now, it's mandatory for a prospective claimant to enter into early conciliation, but it isn't mandatory for them to actually engage in it. So they can fill the form in on the ACAS website, have the initial chat with the conciliator and say, I don't want to talk to my employer, just send me the certificate. Again, you would know in those circumstances that there's been an early conciliation. You would only know when you get the claim form arrive. But also on the flip side, it's not mandatory for employers to actually engage in early conciliation. And that's if you're actually contacted about it by ACAS, which we'll touch on in a little bit. Perhaps more rare, but I always think is a good option to think about, is that employers also have the ability to start early conciliation if they want to do so. It's perhaps a little bit more rare because if you have an ongoing dispute, you're not going to be bringing a claim in the employment tribunal against your employee. That's why it tends to be more employees who will bring them. But if you're already having in-house discussions and you're looking at potentially reaching a settlement and would prefer to go through a COT3 rather than a formal settlement agreement, there is that option there to contact ACAS and start early conciliation yourself if you're not confident the employee will actually do it themselves. Back in the day before early conciliation, if you had an early conciliator at ACAS that you used to speak to quite often, you would sometimes be able to give them a call and ask if they could help. But early conciliation has formalised the process more, but there's the option there for you. Now, in reality, what we're hearing back from a lot of our clients is that either they're not hearing from ACAS at all during the early conciliation process, which isn't helpful at all, or else they're hearing very late in the day. So it's really not having any meaningful time there for you to conciliate. And as a perfect example of what I was saying earlier in terms of employment law always changing, in between sending out our invites to you all today and actually holding the session, the government announced a change to early conciliation that's going to be coming in shortly. Now, originally, if you might remember back when it was first introduced, the time frame for early conciliation was 4 weeks, plus the option if both parties agreed to add an extra 2 weeks. When it was realised from the figures that that actually wasn't giving enough time, and I think anyone's experience might have been at the time you were automatically adding on that 2 weeks. So it was formalised by the government at the time to just instead change it and say that 6 weeks would be the conciliation period. It still hasn't been working. It's meant that ACAS just don't have the capacity to deal with early conciliation in the way that everybody would want them to do that. So what the government has decided to do to try to fix that issue is to double the length of time for early conciliation. So for any conciliation that started on or after the 1st of December, so that's next week, actually, shockingly, there's now going to be an automatic maximum of 12 weeks for conciliation. My gut feel is that almost all conciliations are probably going to last that 12 weeks, purely because that's the experience we've been seeing with the 6 weeks, unless you're already close to settlement anyway. The rationale there is to ease the pressure on ACAS. I don't want to sound pessimistic and start the day that way, but my view is that perhaps it's just trying to put small plaster over a gaping wound, that without changes such as increasing the number of conciliators available, does that extra time mean that the conciliator who's been assigned so many different early conciliations can actually reach out to employers and then have that meaningful consultation? Is that going to work? I'd like to hope so. I suspect the government's having the same thought because they've said that they're going to review it in 12 months to see what impact it's had, if any. Practical implications, positives should give more time to conciliate. Again, probably going to go in the negative side. For employers, there's that impact there in terms of delay. We're already seeing a creaking tribunal system with delays anyway. Anyone who has claims, you sometimes find that even when you go through early conciliation, it might be months before you then receive the claim form because the tribunal is just so busy with their caseloads, they can't issue them very quickly. If we're adding on this 12 weeks now, if we were to assume that early conciliation starts quite late on in that 3-month period, goes for the full 12 weeks, potentially then has that month for a claim to be brought afterwards, and then you factor in the issuing time by the tribunal. And anyone dealing with tribunals in the southeast or in the Midlands at the moment will know that's a very slow process in itself. You could find that, say, an unfair dismissal claim you've dismissed, and then 12 months later you're actually first getting your claim form. I think that's probably going to be the biggest implication of this change on employers and something that's going to be very difficult for you to manage. And we've added on that, as Rachel alluded to earlier, the government, as part of the ERB, is looking to extend the time for bringing a claim from 3 months to 6 months. So what we might end up seeing, and probably what isn't the intention, is that it's going to massively slow down the process for claims and also restrict access to justice in that way. Now, I don't want to sound all doom and gloom, so let's end on a more positive note. So there can, of course, be advantages to using ACAS. Quite a lot of the time, if you've been working through a dispute with an employee, perhaps it's just they've gotten a bit too close to it. They automatically see that you're not moving. It's more of an enemy. It can be helpful to have that independent person to come in and to talk to them, to have that neutrality there, and to get them to listen. And the information piece as well. I don't know if anyone else experiences the same as ours. We're seeing a lot more now where you can suspect AI has perhaps had a hand in a dispute, that what might have been a small point has been put into ChatGPT, and all of a sudden there's a 4-page grievance come out of everything that could possibly be wrong, even if it's not correct. Employees going to see that and think, well, that's what AI has told me, so it must be right. So the information piece that ACAS can do, they can't advise people, but what they can do is tell them the basics of a claim and what's involved, and I think quite helpfully what potential awards are. We're seeing a lot at the moment where people are thinking they'll get awards in the millions when actually an unfair dismissal cap of 52 weeks gross pay might apply. So that is a benefit of ACAS there. And it is quite effective as well. So the statistics for 24-25 financial years showed that ACAS resolved 39% of cases that they received early conciliation. So that's not an insignificant number. And then of those unresolved disputes that end up going to tribunal, over 3/4 then resolved via ACAS before the parties have to go to a final hearing. So they do have that merit there. It's just whether or not with the caseload they have, they can actually be a little bit more faster and a bit more helpful with what they need to do. But of course, you might not always actually want to go through ACAS, and you might think, actually, we can deal with this in-house. So Rachel, what are the options we've got there if you want to deal with it direct?
Yeah, of course. Thank you, Michelle. So as well as trying to resolve disputes using ACAS, you can try to negotiate with employers directly to resolve disputes. Sometimes employers propose terminating an employee's employment on agreed terms before there's even any legal dispute. Often that's because of shortcomings in the employee's conduct, performance issues, it could be wider organizational changes, or simply just comes down to a clash of personalities and it's not working out. Rather than go through a lengthy formal capability, redundancy, or disciplinary process, which carries with it a risk of litigation and negative publicity, it can be beneficial to start confidential exit negotiations at an early stage with a view to reaching a financial settlement with the employee. So this is where you might have pre-termination negotiations known as protected conversations. The statutory framework for protected conversations is under Section 111A of the Employment Rights Act, and that's been around since 2013. This makes it a lot easier for employers to start these conversations because there's less risk of these conversations being treated as a breach of trust or confidence or being referred to in a subsequent procedure, for example, in a disciplinary scenario to show the employer had already made its mind up to dismiss the employee. If you come within the legal framework with these conversations, then they are off the record and inadmissible in any future employment tribunal claim of unfair dismissal. It offers similar protection to the without prejudice principle, but unlike the without prejudice principle, it can apply where there's no existing employment dispute. So that gives more flexibility and allows conversations to take place where one of the parties is unaware that there's a problem. The without prejudice rule may apply at the same time or later if a dispute arises, and it's often best practice to mark all written correspondence as being within both. So when does the Section 111A framework apply? It applies when there has been an offer made to end the employee's employment on agreed terms. The conversations are only inadmissible in ordinary unfair dismissal proceedings. There's no need for the parties to already be in dispute, as I've just touched upon. It doesn't apply to cases where the claimant is alleging automatic unfair dismissal, wrongful dismissal or breach of contract, discrimination or whistleblowing. Also, the framework doesn't apply where there has been improper behaviour. So if anything said or done is improper or connected with improper behaviour, evidence of these pre-termination negotiations will be admissible only to the extent that the tribunal considers it just. It's quite an easy trap to fall into, so be aware of what can constitute improper behaviour. Luckily, ACAS have a code of practice on settlement agreements and accompanying guidance, which outlines what counts as improper behaviour. The guidance is very detailed and useful on the practicalities of proposing and negotiating voluntary exits, so it's definitely worth a read. Examples of what might constitute improper behaviour are putting undue pressure on a party, so from the employer's side, not allowing the employee reasonable time to consider an offer. As a general rule, ACAS recommends a minimum of giving the employee 10 calendar days, unless you agree otherwise, as that gives them a chance to get some independent advice. Also, if you say to the employee, if this offer is rejected, we're going to dismiss you before any formal process is otherwise begun, that will be improper. From the employee side, if they threaten the employer to undermine their public reputation unless they enter into an agreement with them, that would be improper, although obviously that doesn't apply in whistleblowing cases. More obviously, all forms of harassment, bullying, intimidation, physical assault, criminal behavior, victimization, discrimination because of any protected characteristics all fall within improper behavior. ACAS guidance also gives some examples of behavior that wouldn't fall into improper behavior. For example, factually stating to the employee the alternatives of what might happen if an agreement isn't reached. So the next steps when you're proposing a voluntary exit. Step 1, you invite the employee to a meeting. The ACAS code recommends discussing proposals face to face, and it should be at a mutually convenient time and place. The code also says it's good practice to allow the employee to be accompanied to these meetings, but it's not a legal requirement. Just bear in mind it can help progress settlement discussions. The correct approach will always depend on the circumstances and the particular employee involved. In most cases, the employer doesn't want to notify the employee in advance that the meeting of the purpose is to discuss settlement. So step 2, when you're in the meeting, the employer will explain its concerns, for example, the performance issues that have been ongoing or the breakdown in the working relationship in as neutral a manner as possible, and propose an exit with an agreed settlement package. You can ensure that the employee is aware of the possibility of, for example, disciplinary or capability proceedings that may follow if the employee chooses not to accept the offer. But as I've just explained, employees shouldn't be put under any undue pressure to accept an offer just because of this. So next, if the employee agrees to consider a possible voluntary exit, you would prepare a written offer letter for them to consider. You can also provide a draft written settlement agreement at this stage, but that might depend on how the conversation's gone and how confident you are that the employee would be considering this as an option. As I mentioned, they should be given a reasonable period to consider this offer. So a minimum of 10 calendar days is ACAS guidance. Um, if it looks like the employee is interested, you then provide them with the settlement agreement documenting the terms in full, and the employee would then take that away to get independent legal advice on the implications of them entering into the agreement. If the employee is not interested in exploring settlement, you should cease settlement negotiations and seek to tackle the underlying problem, maybe through a formal process. If settlement talks stall, it's not unusual for an employee to switch tactics. One common move is using a data subject access request as a pressure point on employers. These requests can be quite burdensome. You'll know if you've ever had to deal with one, and can often come at quite a critical stage if there is a dispute. So, Michelle, what practical steps can employers take to manage data subject access requests effectively?
Yeah, so just to reassure everybody that for the last few minutes, I'm not going to bore you to death with everything about subject access requests because it would take a few hours of itself. But through the lens of disputes and employment tribunal claims, it might be similar to your own experiences. We are seeing a massive increase in employees making subject access requests, either at the start of a tribunal process or beforehand, generally with the aim to try and get documents because it's recognised for the process as employers you will likely hold a lot more documents than employee will. So quite often it will be either specific to the matters that they want to raise as a claim, or else it will be a very wide request that's really a fishing expedition to try and get that smoking gun for their claim. Also, the more cynical side, it might be that given the time and effort you have to put into responding to a subject access request, it's to cause you as much trouble as possible, or even to try and twist your arm a little bit if you're having settlement discussions. No, unfortunately, whatever the motive, you still need to respond to a subject access request, and you need to do so within that deadline of 1 month or the up to 3 months if you've got a reasonable ground that you need that extra time. Interestingly, as we were talking about with the extension for early conciliation to the 12 weeks, that will tie in quite nicely with someone who's going to look and do a subject access request that you're potentially going to be having to respond within that period. We're already seeing a lot of claimants in claim forms where they will specifically refer to things that they've read in a subject access request disclosure. So I wouldn't be surprised if we see an uptick in people who are going to be doing the same as well. Now, you do have some exemptions for subject access requests. One that gets banded around quite a lot is where the request is manifestly unfounded or excessive. To put a health warning on that, that is a very, very high threshold to meet. So if you're thinking it might apply, always speak to your data protection officer and or take legal advice as well to make sure that it's something that you're able to do. And it's always worth remembering a lot of employees, especially if they've got in mind a tribunal claim, will think that a subject access request means they get absolutely everything. It's only the data you hold about them. So you can potentially redact some of the information about third parties in a document. Again, another health warning, just be careful with redaction. If you're then going through a tribunal process and have disclosure and a document is relevant to the issues, it's very difficult to get redaction, to have a judge agree to that. So you might find that something you've redacted, if you've accidentally redacted more than you should have done, employee might then see it during the tribunal process and kick off you've not responded to subject access requests properly. And always to end on that note of caution, we do see from time to time claims that come about purely because something's been disclosed in a subject access request that has either given an individual decent grounds for a claim or else has sort of led them to believe that they might have grounds for a claim. So as always, really do take care of what's committed in writing. To sort of add a modern twist to things, if you want to put something in an email that you wouldn't want them to see a TikTok video, having it in the background while someone's dancing in front of it, think about whether you should commit that to writing or even if it should be said at all. But that is our whistle-stop tour around pre-claim issues and potential tactics and options. And we really hope that there's been some helpful takeaway points that's going to assist you when you're dealing with disputes and potentially heading towards the employment tribunal. As a reminder, this is the first of a 3-part series. Our next session is going to be on the 14th of January, where Bethan and Molly are going to be looking more at tribunal proceedings in action. So please do sign up for that if you haven't already. Now, we know that it was up until 10:30. So if you need to log off now, thank you for joining us. We will send you the recording afterwards. Rachel and I have kept ourselves free for the next 10 minutes or so, and I can see we have had some questions come through. So we're more than happy for any of you who'd like to stay and join us. We will chat through some of those questions now, but if you're not able to, thank you again for joining us. Rachel, did you want to go first with one of the questions?
Yes, of course. So I've got First question here. Are there any proposed changes in the Employment Rights Bill to employment tribunal practice? For example, more cases to be heard by judge alone to help reduce the backlog. We are seeing cases being listed for 2028. I can empathise with you. We're also seeing
Certainly can.
cases being listed a long time in the distance, which makes it so difficult to deal with. The witnesses are likely going to have forgotten everything by that time. So there is reform needed. There's currently no new statutory reforms proposed within the context of the Employment Rights Bill. There's no specific requirement, for example, for more cases to be heard by a single judge, but there are some separate measures that are already being put into place to help with delays. One of them is digital modernisation, so the ET systems being modernized. There's a new My HMCTS portal. It's helping to streamline all the admin and saving judicial time as well. And there's also more of an emphasis on using a single judge when it's appropriate to do so, particularly for smaller or undefended cases. So the single judge hearings came into force via 2024 practice direction. So hopefully we'll start to see more cases being listed with a single judge. Michelle, did you want to answer any of the questions? There's a couple more of my topics I can talk about, but maybe we can alternate.
Sure. I mean, sort of tacking on to what Rachel was just saying on the single judge, and there's a similar sort of question that I'll pick up as well. What we are seeing a bit more of now is that a standard at preliminary hearings, because if it's an unfair dismissal claim or a wages claim, they tend to be judge only anyway. But it's more your discrimination, your whistleblowing claims. We're seeing a lot more at preliminary hearing stage now, parties being asked, do you prefer single judge or panel? My experience tends to be that claimants will push for the panel because they've read upon it or it's explained at the hearing, and that there's the employee-friendly panel member, the employer-friendly panel member. So quite often claimants push for that. I am starting to see a little bit more that judges prefer to list with judge only. And obviously the government, was it yesterday, has announced they're looking to remove jury trials. So whether or not we're going to see more focus on judge only spill over into the employment tribunal could well happen. But we have also had a question which I think sort of nicely leads us on to that in terms of the use of AI lawyers, as I mentioned earlier, and whether or not there's anything that could come in terms of reassessment by the tribunal or ACAS to manage the situations, because it's really tying employers' hands. And I absolutely agree with you. One of my biggest bugbears at the moment is that we are seeing matters which realistically should be one or two complaints now getting into the 20, 30, 40 different separate complaints, which generally is because someone's gone through AI and decided that. Alongside that, I mean, generally the process should be that kind of claim would go to a preliminary hearing for case management. Parties are trying to agree the list of issues, judge should input. What we are starting to see for a large sector of employment tribunal claims, we had an EAT judgment not that long ago where it looked at list of issues and what judges should and shouldn't do. I think there's a little bit more caution when it comes to discussion of list of issues from judges at the moment, where it's a bit more difficult on the respondent side to say this shouldn't be there for this reason or that reason. But equally, we are seeing a bit more of a trend now that judges are more open to having substantive preliminary hearings, looking at strikeout or requiring applications to amend. So those tend to be through the tribunal process. Your only real options as an employer, respondent side, to try to whittle down the list of issues to focus on the key points. And I realise that I've suddenly just gone in the dark. I'm not sure what's happened there. And otherwise, it will be a usual approach. If you think that there's an issue there and it's it's a claim without any merits at all, you might be looking at strikeout, but then you've got the option there in sort of legitimate cost warnings and dealing through ACAS. But I absolutely share your frustration with that, and it's something that we're seeing and struggling with in terms of the AI lawyers.
We've also had a question touching on flexible working requests, asking what does objectively reasonable mean in the case of refusal of a flexible working application. So in practice, it means the tribunal is going to look beyond the formal process and ask, would a reasonable employer acting fairly have refused this request in this employee's specific circumstances? So practically thinking, it's going to be really important to document your reasoning. I mean, it's already important to do so for flexible working requests, but even more so now with this new extra qualification that's required. So you should clearly include the business reason that you've relied upon to reject the request, why that reason applies to this specific role, and also consider what alternatives there might have been and why these weren't viable. And that can help with proving this reasonable qualification, because I appreciate it does sound quite vague.
Yeah, and it's one of those things that will come through in practice, and it goes to
Hmm.
tribunal a bit more. We'll see a bit more guidance, I think, come through case law if it ever gets to the point. It might be a good 5 years before it does. Now,
Yeah.
there were a couple of questions in terms of ACAS and COP3, so I'll bunch a couple of them together. Now, in terms of early conciliation, where employee doesn't want to engage, whether or not you should still get the early conciliation certificate, I find it a bit hit and miss with ACAS. If they've spoken to you a little bit and they've got your contact details, you might get that certificate. If they haven't spoken to you at all, in my experience, they don't send it to you. It potentially is because they haven't confirmed your contact details. What you should be getting, and the first time you might see it, is actually when a tribunal claim lands, because the tribunal should, as practice, be attaching it with the ET1 claim form when they send it to you. And there was a question in terms of benefits of a COP3 over a settlement agreement in-house. What quite often the benefit tends to be is the input of independent legal advice. So if you've got a matter where actually there's an agreement, or there's something we're potentially concerned about, somebody going off and getting legal advice and potentially reopening negotiations, that might be where you think actually a COP3 would be better, to try and, we don't need all the bells and whistles that come in the settlement agreement. Let's just get a COP3. And there are, of course, a handful of claims that you can only settle under a COP3 and not a settlement agreement. But then equally, someone's asked the question in terms of if you do employer-led early conciliation, is it feasible with delays to ACAS? And that's another issue that you've got to take into account as well. You could be starting off early conciliation next week, and then you might get week 11 to suddenly get in contact, whereas actually at week 1, you were so close to getting an agreement with employee. Are you better off going down that settlement agreement route? So I'd say it depends on the particular circumstances, and also the kind of employee you're dealing with. If they're not really following perhaps the negotiations you're having, or they're quite stuck in the mud about what they want, then a settlement agreement might be better, and get them to go off and see and get legal advice. Rachel, were there any other questions?
Yeah, there were
Or
a
have we covered
couple of
them?
questions on protected conversations, so I'll answer a couple of those to finish us off. So one question was, who should initiate the protected conversation process? As I mentioned, either party can initiate a protected conversation. Obviously, in practice, it's normally the employer who starts the process, because the typical triggers are things like performance concerns, organizational changes, relationship breakdowns, and it's usually beneficial for the employer to avoid lengthy procedures and litigation. Employees can still initiate these conversations, but it's a lot less common in practice. I had another conversation asking, do performance management processes have to pause whilst a protected conversation is taking place? There's no legal requirement to pause an ongoing formal process, but I think to keep the process fair and avoid any allegations of improper behaviour, it might be best to put a little pause on the process, so you're not seen as using that process as any kind of leverage in those protected conversations. Okay, I think we've run over by an extra 10 minutes, so that's probably all the questions we have time for today, but feel free to get in touch with either of us if you have any further questions. Our contact details are up here on the slides, and the webinar recording will be available, as well as the slides, which I believe will be shared with you afterwards.
And it's just to end by saying thank you all so much for joining with us, and for the questions. It's always great to see interaction and to understand a little bit more from you guys what it is you're experiencing and the key things you're looking at the moment. But otherwise, just on behalf of myself and Rachel, thank you so much for joining us this morning, and enjoy the rest of your day.
Thank you, everyone. Goodbye.
Goodbye.